Well, good morning, everybody. I make it 10 o'clock on the dot, so welcome to our webinar this morning. I'm delighted to be joined by Helen Jago, who's a private client partner at Palmer's. Welcome, Helen. This webinar is all about the latest developments in wills and probate. So I shall hand over to Helen shortly. Just a couple of housekeeping issues before we get going. We are planning to run a Q&A session at the end of the presentation this morning. So if you're familiar with Zoom, just click the Q&A tool on your toolbar, and that will enable you to put any questions to Helen that you'd like to ask throughout the presentation, and we will try and answer as many of these as we can before we finish today. We are also recording this webinar, so we'll make an on-demand version available on the website later on today and notify you by email when that's available. So if you do want to go over any of the points that Helen's raised, we will have that available to you. Okay, well, I will now hand over to Helen, and I'll see you at the end for our live Q&A. Over to you, Helen.
Oh, thank you, Jo. Thanks for the introduction. So some of you might be aware I presented a webinar in June last year focusing on wills and probate during lockdown. In that webinar, I dealt with the current inheritance tax rules and also the intestacy provisions which apply if you don't have a will. So I'm not going to cover those again. It's not going to be a repeat of last time, but if those topics are of interest, then the original webinar is still available to view on the Palmer's YouTube page. The reason I'm doing another webinar now is that since that webinar less than a year ago, the ability to sign wills virtually and a compulsory move to online probate applications have since come into force. So with those changes in mind, I prepared this second webinar, and you will see on the slide the questions which I'm going to be addressing today. And as Jo said, I'm more than happy to take questions at the end of the presentation. So what I'm going to be looking at is, how does virtual will signing work? How can I protect my share of my house from my children? Is a question I always get asked. So I'm going to do a little focus on life interest trust wills. Online probate, how's that working out? And finally, can Palmer's still help us with wills, probate and trust during lockdown? So moving on to the second slide. Virtual will signing. And I guess it's a sign of the severity of the current situation that the Wills Act 1837 has temporarily been amended to allow for virtual will signing. People have talked about amending it for years, and finally this has brought about a sort of temporary, at least, change. So the amendment itself is contained in the Wills Act 1837, Electronic Communications Amendment Coronavirus Order 2020. It came into force on the 28th of September 2020. But note the time frame here. So it applies to wills made on or after the 31st of January 2020 and on or before the 31st of January 2022. So at the moment, we've got this 2-year window where virtual will signings are permitted. I wouldn't personally be surprised if this was extended or perhaps even used as a trial for modernising the Wills Act on a more permanent basis, but we've just got to wait and see. I think it was really brought in because people were just doing virtual will signings, and they've kind of almost retrospectively made them valid. What the amendment does is it basically provides that where the witness of the will must be present for the will signing, as is traditionally the case, presence can now, during that above time window, include presence by means of video conference or other visual transmission. So that's what it says. So moving on to slide 3. In order to understand how virtual will signing works, we just need to really have a look at the actual basics of will signing. So in order to sign a will correctly in England, for it to be valid, the testator, that means the person who's making the will, must sign it, and that signature must be made in the presence of 2 adult witnesses. The witness must see the testator sign the will and should ideally also see each other witness the will. The witnesses shouldn't be anyone named in the will or married to anyone named in the will. For example, I was once asked just to briefly review a simple homemade will for a client who was just instructing me on a separate trust matter. On coming to the end of what was otherwise a perfectly fine will, I thought it was all fine, but I noticed that the witness had the same name as her daughter. A quick inquiry confirmed that her daughter had in fact been one of the witnesses to the will, and perhaps worryingly, this would have had the effect of writing her daughter out of the will completely. The same would have been true if her son-in-law had been the witness to the will. Obviously, in that case, the lady had that opportunity to make another will, but had she not asked me just to quickly review the will as a sort of a second thought, it might have been uncovered too late for that daughter. The problem, therefore, during lockdown is how can the witnesses actually see, or more technically be in the presence of, the testator when we're all supposed to be staying indoors as much as we can, and some people more so than others if they're isolating or, you know, carefully shielding. So moving on to the next slide. How does virtual will signing work? So all of the requirements of a correct will signing remain the same, the ones I've just gone through above, except that the witnesses can now see the testator sign by means of a live video call. And the government have produced guidance on how they think virtual will signing should work in practice. It is just guidance, but I've set out the link in the slide, as you can see in blue there, and I'm just going to seek to summarise the main points. So basically what happens, the testator sets up a video call with the other two witnesses on the video call. It's worth noting it just doesn't matter what type of video call it is, so it can be Zoom, WhatsApp, FaceTime, Skype, whatever, it's all fine, but it has to be a live video, it can't be pre-recorded. So I can't, for example, think, oh, I'll record myself signing a will and then I'm going to WhatsApp that video to my friend saying, you've watched me sign the will, can you just witness it in your own time when you get a chance? That won't do. It's got to be a live video call. Everyone has to be there at the same time. The two witnesses must make sure that they can see where the testator will actually sign on the will. So not just over the back of, see their back or their arm. They've actually got to see where the pen is marking on the paper. The witnesses need to confirm that they can see and hear okay and acknowledge that they are going to witness the will. This is all in the guidance, this bit, not in the act itself. At the end of the will, there's always an attestation clause, which basically confirms that the testator is signing his or her will in the presence of two witnesses who are also present and who also sign the will. And you'll always find this standard clause in solicitors' wills or even homemade wills, but that precedent clause will need amending to confirm that the will is being witnessed remotely, and that is important to amend the attestation clause there. It recommended in the guidance that the testator holds up the front page of their will and the page which they will sign. And then once you've all established, you're all set up, everyone can see, everyone can hear, the testator then physically signs the will and enters the date of their signature. And it's worth noting that we're not quite so modern yet that electronic signatures will suffice. So I've got an electronic signature now to sign off my letters at work. I can't sign my will like that. I have to good old-fashioned ink on the page signature for my will. So moving on to the next slide. I'm going to look at the virtual witnessing of the will. So once the testator has signed the will, it's actually not complete until the two witnesses have also signed the will as witnesses. And again, we're talking about ink on paper. The will needs to be sent or handed to the witnesses. So this perhaps demonstrates we're not totally in a modern position yet, because the testator's still got to perhaps, one option might be to post the will through the door after they've signed it if the witnesses are waiting outside. or the testator or someone on his or her behalf would need to literally physically take the will to the post office and post it to the witnesses. Once the witnesses have got the physical will signed by the testator, the witnesses then need to sign the will, again in the presence of the testator, and also the virtual or physical presence of each other. So this is another video call, possibly another 2 video calls for each witness. The witnesses sign with the date they sign. And this is really important. The date of the will is the date on which the last witness signs the will. So this could, if you're using the post each time, and we all know what the post was like over the Christmas period, this could be several days after the testator signed the will. So that's just worth bearing in mind. So next slide. So do we think virtual will signing is now the best way? In my opinion, no, not generally. And the reasons for that is the guidance itself suggests that the use of video technology should be a last resort at the moment. It does encourage people to try and arrange physical witnessing of their wills where it is safe to do so. As mentioned above, the will is not finalised, it's not legal until the testator and the 2 witnesses have all physically signed the will. And so this means there is likely to be a delay between the testator signing the will and the will becoming valid. If the testator passes away in the meantime, as mentioned, the will's invalid. So probably often it's easier to arrange a safe, socially distanced will. As mentioned, you need to sort of do a special attestation clause, and the one in the guidance is actually quite lengthy, and it almost puts an onus on the witnesses to confirm the testator understands the will, has capacity, is making it of his own accord, etc. And traditionally, witnesses literally that testator sign the will, nothing else. So I think people, will need to be careful if they're adopting that standard guidance there from, standard clause from the guidance there. But I do think in limited situations, it can be a useful alternative. So for example, if I've got a will client who has tested positive for COVID or is carefully shielding and wants to make a will, they could sign the will by video call, perhaps with myself and a colleague standing outside their house, socially distanced. They could arrange for it to be posted outside the front door. We could collect it, perhaps wearing gloves and a mask, restart the video call, and then each witness, standing socially distanced ourselves, could witness the will. So it might be possible through that use of video calls to get everything signed on that same day, especially perhaps if they're upstairs in a room without a window. What I would just say is that often it's proving possible to achieve that same result where a person sits inside in their house by a front room window, and that counts in the more traditional way of being in the presence of that person. But at least now we have got a few options available. Moving on to slide 7. How have Palmers dealt with the will signings during lockdown safely? So we haven't actually, as mentioned above, kind of indicated, we haven't really used virtual will signings too much at all, but instead what we've managed to do is continue to assist our clients as safely as possible by taking the following steps. So what we've been doing is taking instructions, viewing identification by way of video call in the first instance. We've emailed drafts, accompanying letter of advice to our clients, and then obviously we prepare the top copy wills for signing. Now, the signing part is the bit that you need some kind of interaction, as mentioned above. So what we were doing in the summer was witnessing in people's front gardens, or at the moment we've got our offices as COVID secure as we possibly can, or we send out very detailed instructions for the signing of the will, again, which people could perhaps do in the presence of neighbours, even outside where possible. I've covered actually in detail how we managed this in practice in my last webinar, so I'm not going to go over all the practicalities of how we've been doing that and some of the examples again today, but that webinar is still available if that's of interest. So moving on to the next slide, the importance of recording the will signing. And it's worth noting that whichever type of will signing is, that the means and method of the will signing are recorded somehow. The guidance actually recommends you might want to record the video call, so you've got a permanent record of that will signing and that it was all done properly. Obviously, it's important it is all done properly, or you've got proof that it's not. Alternatively, more traditionally, a written or typed attendance note of how that will signing was conducted, and I think that is crucial. Moving on to the next slide. So is there a need for legal advice? You can, of course, prepare your will yourself, but what I would say is that a will is an important document. Don't forget, often, especially with property prices now, you're often dealing with hundreds of thousands of pounds of property or money. You want your will to be valid. Although virtual will signing sounds easier, it is actually still essential to get the formalities right. As mentioned above, it can actually, the virtual will signing, make the process more complicated and sometimes more lengthy. If you instruct a solicitor, they will record the will instructions, make notes on the capacity of the testator, check that no one else is influencing the testator, and record how the will signing was carried out. So all in all, our job is to make sure the will is correctly made and ideally correctly signed, hopefully. So moving on to the next slide, now I've had a look at the formalities of signing a will, I'm going to move on to cover the area of life interest trust wills. The reason I'm touching on this is because it's something I frequently get asked about. So I just thought I'd summarise what a life interest trust in a will is like in this webinar. So a life interest trust is where the testator grants someone a right to benefit from a certain asset or even his whole estate for life, but ultimately it will pass to another person or people. So, for example, husband Daniel leaves his house to his wife Helen to live in for her life. Helen can live there rent-free for the rest of her life. She carries on paying the bills and the outgoings. She can move if she wants to and obtain the rental income from the whole property if it's rented out. But ultimately, the house will pass to Daniel's children and it as set out in his will. You would always need trustees to look after the assets in the trust. However, note this doesn't have to be some complicated system of third parties or costly lawyers or accountants or trust companies. It can be just the wife and the children in that example, but it could also be someone totally independent, like a solicitor or a friend or a sibling, someone that the testator trusts. And it's worth noting, where you've got a life interest trust, you do need at least 2 trustees appointed in the will. So why use life interest trust wills? On the next slide, I've set out some of the main reasons. And the first one is perhaps to protect against a spouse remarrying and leaving out the testator's children. They're especially common where there's children from previous relationships, so if there's a second marriage or second relationship. Another very common reason that people want to include life interest trusts is where they want to protect against the first to die share of the assets being used for the survivor's care fees. Another reason might be to protect against the possible bankruptcy of the survivor. And finally, they can also be used as a way of inheritance tax planning. I'm not going to cover that in detail in this webinar, but it's generally where the life interest trust is drafted flexibly and allows use of the spouse exemption and future distributions to others, such as the testator's children. So moving on now to the next slide, I'm going to look at a couple of case studies to try and sort of give an example of how they work in practice. So in my first case study, let's take a married couple. We've got Anne and James in their 60s. They've got 3 children and 2 grandchildren so far. Let's say they've got a joint property worth approximately £450,000, which is mortgage free. Let's say they've got savings in the bank about £55,000. They've come to me with an objective and they said, we want to make wills to ensure that the survivor is sufficiently provided for on the first death. We want to make sure they're secure, but we also want to make sure our 3 children have an inheritance. They inform me that they've worked hard to pay off their house. They would hate it all to be used in care fees if the survivor of them needed long-term care. I find out that they're happy that the bank account, which is in their joint names in any event, will pass to the survivor of them, absolutely. But they would just like to know that if one of them dies, at least their half of the property will pass to their 3 children. So in this sort of case, I might suggest that they consider both including a life interest trust in their mirror wills over their respective half shares of the property. So it's firstly worth noting that in order for Anne and James to leave their half shares of the property to the life interest trust in their wills, they must own their property as tenants in common. So when Anne and James first come to the appointment with me, I will look at their deeds to see how they own the property. If they own it as joint tenants, their half shares can pass to the trust in their own respective wills. This is important because with a joint tenancy, the property would otherwise automatically pass to the surviving owner, regardless of the terms of the will. So we must do that step first. Let's say we then include life interest trusts in their wills in respect to the property, with everything else passing outright to the survivor of them. We've also severed the tenancy to make sure the property can pass under their wills. So that's all set up. In years to come, if Anne passes away first, James will still have his half of the property to deal with as he wishes, but Anne's half will be in trust. James will benefit from Anne's half during his life. And because of that, the initial gift to the life interest trust under Anne's will for the benefit of James for his life will be inheritance tax exempt because they're married and there's the spouse exemption. So that's the same really as if Anne had made an absolute gift to James of her share of the property from a tax point of view. The will would probably say that James will continue to pay all the outgoings and insurance in respect to the property, just as if he owned it himself. So in practice, little will be different. But if James then needs care, he will only own his half of the property, which can be used towards the payment of his care. Anne's half will not belong to James, as this is in trust. So Anne's half at least will pass to their children. Similarly, if James remarries and falls out with his children, although he can do as he wishes with his own half of the property, Anne's half of the property will be in trust for her children. James could not divert Anne's half to his new wife or anyone else. So moving on to case study 2. I've got another married couple now. I've got Lydia and Peter this time. They've both been married before. Lydia has 2 daughters, Emma and Sophie, from her first marriage. Peter doesn't have any children, but he's got a nephew who he's really close to, Anthony, who he wants to benefit on his death. Between them, they've got a property worth $800,000, which is mortgage free, and this is already owned as tenants in common. It's owned 60% for Lydia and 40% for Peter as tenants in common. Lydia, say, got $100,000 in the bank, and Peter has, say, £40,000 in an ISA. They come to me with the objective to make sure that the survivor can stay in the house for the rest of their lives or until the survivor remarries, but ultimately their respective share is to go to their respective side of the family. So Emma and Sophie in the case of Lydia and Anthony in the case of Peter. So again, what I might suggest here is that a practical solution might be to include either a full life interest trust that we've discussed above, or perhaps a more limited right to reside trust, which is similar to a life interest but stops when the person moves out, or perhaps a right to reside and move trust, which is similar to a right to reside trust, but where the trust can be carried over to a new property. That will be up to the clients to decide. In any event, whichever option, whichever type of trust they use, Lydia's 60% share of the property can pass to her daughters Emma and Sophie. And so even if Peter falls out with Emma and Sophie, he cannot redirect Lydia's share or use Lydia's 60% himself. The clause could be drafted to allow Lydia's 60% to be reinvested into a new property for Peter to live in during his lifetime, so he can move if he wants to, but that interest in the new property kind of ports across and is held on the same terms as the original property. So the benefit of this trust is that Emma and Sophie cannot force the sale of the property while Peter remains living there, so long as he's not remarried. So Peter feels secure, Peter's protected, but Emma and Sophie are also safe in the knowledge that ultimately their mother's share will pass to them. So often both parties feel kind of safeguarded with these kind of trusts. Peter's will would mirror Lydia's, except that it would cover his 40% interest in the property, and obviously ultimately this would be on trust for his nephew Anthony. With regards to their savings, they may decide to leave their share of the savings directly to Anthony / Emma and Sophie, or they may be happy this passes outright to the survivor. They may alternatively say, again, they want to place the money or some of the money in a life interest trust. So in this example, Lydia could decide to leave her savings to Peter for his life. Traditionally, certainly when dividends and interest were higher, this would mean Peter could have those interest and dividends from those savings for his life, which might be, supplement his own income. But ultimately, that underlying capital would be preserved for Emma and Sophie. So they're really quite flexible. Moving on then to the next slide, what I'm seeking to do here is outline some possible complications. So you've seen from above that actually life interest trust can be a fairly standard way of protecting a person's share of their family home or indeed other assets for their spouse, but ultimately ensuring their children or other descendants will one day benefit from their estate. However, there are some situations where a life interest trust can complicate matters perhaps a bit too much, or at least a consideration needs to be given as to the benefits and the disadvantages. It's always worth getting specialist advice if you're thinking of including a life interest trust within your wills. Not only have I seen some shockingly bad precedents out there, for example, where there's a life interest trust for the survivor for life, and then it's ultimately left to the residue, and the residue passes to the survivor as well. So there's things like that out there, but also some situations just don't really work that well with life interest trusts. In the 2 case studies I referred to, they work really quite well. But if, for example, the property is subject to a mortgage and there are insufficient funds in the first to die's estate to pay off that mortgage, then in that situation, the survivor really can only live, the survivor's got no choice really but to either fund the mortgage or sell the property. And so really all the first to die is leaving is their equity perhaps envisaged. I think this situation with mortgages is complicated further if the parties have joint life cover to pay off the mortgage, because with joint life cover, often it will automatically pay out to the survivor. So again, all the first to die can really leave in their will is the equity in the property. The survivor will receive the life policy proceeds directly, so they've got that sum of cash. but it's up to them really whether they use that to pay off the mortgage. And if they do, arguably they're sort of buying an increased share in the property. So perhaps in that situation, we would look at, does consideration need to be made as to whether separate life cover perhaps is required. Please also note as well, where you've got unmarried couples, it is a bit more complicated, and sometimes a life interest trust can have adverse inheritance tax consequences. Obviously, that depends on the value of the estate and the circumstances. Life interest trust can be a really useful way of safeguarding assets for your children, especially against the survivor's potential care fees, remarriage, bankruptcy, etc. But also a way of making sure you provided protection for the survivor of you. But as mentioned, a careful consideration of the exact circumstances of each case is required to ensure that a life interest trust, or perhaps a right to reside or right to remove trust, is right for you. So moving on, I'm going to finish with wills there and just move on to a brief probate update. So if the worst happens and you do need to apply for probate for a loved one, then Palmers can still assist with this even during lockdown. And just to recap on how we've been doing this, it's largely been through the use of video calls, using email, online probate platforms. So contact has been minimal. We've been really trying to keep that as safe as possible, but keep that moving for everyone and our clients. So how are they working? These online applications. Next slide, Jay, thank you. What I want to touch on today is how the online probate system is currently working. So are mandatory where you can use them. So if you can use them online, you must now use them online. There are a few exceptions. So where there are certain foreign elements to a will. So recently I've had an estate involving a French domicile testator. And in that case, the online process wasn't available to be used, but there was a new paper form which we had to fill out, and that's replaced the old statements, oaths and statements of truth. It's worth noting that even though it's all appears to be quite digital, a legal statement and an IHT 205 or an IHT 400 are still all required. So it's really actually not that different from the previous paper system. The executors are still required to actually sign a legal statement, although thankfully this doesn't have to be sworn anymore, which is a blessing at this time. But the legal statement and the IHT 205, also signed by the executor, are sent to the probate registry. If an IHT 400 is required, which is normally where it's more complicated or there is inheritance tax to pay, then the paper documents are still sent to HMRC. They check through, receipt it, and give that back before I can send the legal statement to the probate registry. The original will is still sent to the probate registry. So from my end, I still needed to attend the office to send out the original will, signed legal statements, and the signed inheritance tax returns in either form IHT 205 or IHT 400. I would just mention as well the question I always get asked, the $1 million question, how long will it take? And all I can say, I'm afraid, is it's really unpredictable at the moment. Traditionally, I could have always said 10 to 14 days and it would be there, on the dot. But since this online system, I've had some probates really quick, back within about 3 weeks, and others have taken several months. It does seem, I think they've been getting a little bit quicker, so there's hope that perhaps the probate registry are coping better and getting to grips with the new system. So maybe I have seen a slight increase in the speed to perhaps a few weeks rather than months. Unfortunately, where paper applications are still the only option, they do seem to be taking longer. That's not just from my experience, that is all the professionals and other solicitors jumping up and down about that fact. Let's just hope they keep on top of things. So finally, slide 18, final slide. Can Palmers still help me with wills, trusts and probate during lockdown? Yes, as you've seen, you can still make your will during lockdown. We'll talk you through the most practical and safest way for the witness inside of your will and even the taking of the original instructions. Yes, you can still apply for probate during lockdown, and we can assist with this. We're working on a rota system in the office, so we've reduced staff numbers and are working from home where possible when we're not in the office. But there's always a small team in each office to ensure that post is collected and processed daily, and that probate applications can still be sent out, because as we've seen, the original documents do still need to be sent by post. Palmers will assist you professionally, sensitively and safely. And to begin your will or probate application, or just to inquire how we can help, you can always email us, phone. My details are set out there. Obviously, there's a website with each office's number, and we've also now got a new cloud system as well. So you just literally go on the Palmers website and it says start your will now, and so that's another kind of new innovative way we're trying to help our clients make it a little bit easier to start the will process. So I hope that's provided a useful summary, and I'm now going to pass you back to Jo to raise any questions she might have received.
Great, thanks, Helen. Yes, lots of questions coming in. So let me just start going through some of these. First one in from Angela. I think a will's been on her to-do list for a long time. She's remarried and they've got children from different, obviously together, but from different relationships. I think she's looking to know where to start and what documents she needs to pull together before she actually starts talking to you.
Okay, so what I would say is, obviously anyone can get in touch at any stage of the process, so she can email and I would happily send over a little questionnaire with some things to think about. And what that really involves is, who do you want to get your estate ultimately, and ideally a rough idea of your assets and liabilities, the approximate value of the house, approximate amount you've got in your bank, and then obviously perhaps make the appointment, and then we would talk through what your objectives are and how best we can make sure the beneficiaries get what you want them to get.
Okay, a question here from Paul. When you go back to case study 1, how does this work in regards to deliberate deprivation of assets?
Okay, so I think what Paul is mentioning there is that you're not allowed, quite correctly, to deliberately deprive yourself of assets which will avoid you paying your own care fees. So if, for example, I give away my property to my children because I don't want to pay for my care fees, and I say, well, I haven't got a property, I've given it away, then the local authority will say, well, no, hang on a minute, you've deliberately deprived yourself of those assets, so you don't have to pay for those care fees. There might be other reasons people give something away, but certainly if that's clearly the only motivating factor, that will be set aside. Where life interests come in is the person. So let me just go back to that example, case study 1. In that example where we've got Anne and James, Anne's passed away. She doesn't need care. She's just passed away. She hasn't deprived herself of any assets. When James later needs care, he has his own half that can be used towards his care, but he hasn't given away Anne's half. That was just never left to him. All he had was a right to live there, a right to move, a right to the rental income. And if he's got a full life interest, that rental income from Anne's half can indeed be used towards his funding his care. But the capital of Anne's half is preserved for her children, because that just simply has never been left to James. So, but essentially, the one needing care hasn't deprived themselves of any of their assets.
Okay, and I think that answers William's question as well, which is, do I understand that you say in a life interest trust in a will, it could prevent a charge being taken by the local authority to cover care home fees?
Well,
I think that's one of the same thing.
Sort of. I mean, with I have seen quite commonly where you've had that, where the first spouse has either left an outright gift to their children or a life interest trust gift to their children of their half, and then the survivor does need care. The local authority will sometimes if the local authority doesn't want, if the family don't want to sell the property, the local authority will sometimes put a charge even on that half of the property, or it can be sold, of course, and the children get their half, and James would get his half towards his care. So you're not protecting the whole property, but as I say, and at the moment, you're not depriving yourself of those assets because James isn't the one needing care. So sometimes it can complicate with a charge, because obviously then the trustees would need to consent to that.
Okay. Another question in relation to life interest trusts here. Can the surviving spouse sell the property to downsize, for example? And what remains in the trust in that scenario?
Yeah, so it depends on how the trust is worded. So if you've got a full life interest trust, how I word mine is that they've got the trustees would have the ability to essentially use that trust money to buy. So in that example, we said downsize, didn't he? So they buy a new property. At that time when they buy the new property, they would say, right, well, okay, how much does James, let's just take Anne and James again, he's a survivor, how much of the new property does James own? How much of the new property does the trust own? And probably I'd recommend that a trust deed is drawn up at that time, just saying it's 60-40, or is it still 50-50, etc. So let's say in that example, they downsize to 350,000 and the new property was owned still half to the trust, half to James. They've got 100,000 left over. James takes his 50. He can do what he wants with that. The other 50 goes in a bank account or an investment, and then James gets the interest. But ultimately, half the house and that 50,000 capital is protected for their 3 children.
Okay.
So they can move. They can move. We would always make sure of that. Yeah.
Okay. Thank you. And again, the obligations of the trustees of a life interest trust, what obligations do they have? So, for example, record keeping.
There's not too much to do with the life interest trust if the person is just in there, because it's not a discretionary trust where the trustees it's much more onerous. They've got their own, they've got to make decisions and things. Here, if the person's just living there, there's really not much to do. What we probably say is, ideally, you'd want to maybe see a copy of the insurance and have the trustee's interest noted on the insurance policy. That's probably about it, really. Obviously, if the person wants to move, that life tenant wants to move, then they will need, the trustees will also need to sign the transfer for sale. So you don't want to choose trustees that will be awkward or difficult, the transfer for sale. And I guess if they end up instead with, rather than a property with the life tenant living there, if they've got a big pot of cash, then they may well want investment as to how to invest that asset to produce not only an income for the life tenant, but also perhaps capital growth for the ultimate beneficiaries, the remainder men.
Okay. Right, this is a question that doesn't relate to life interest trusts, but it's an interesting one. So this is coming from Leslie. I live and work now in Iraqi Kurdistan. Before he moved there, made a will, it's with Palmer's actually, and was updated 9 to 10 years ago when the circumstances changed. The situation is that now less than able to return back to Britain at any time or in the near future. So if they were to die in Iraqi Kurdistan, what would happen in that position? And would their executors be able to manage matters arising from them being abroad? So, for example, bank accounts and property.
Okay, so it's quite a specific question, but I think if you've got if the person's got assets, then that's fine. The English will cover that, and the executors, certainly if they're based in the UK, can deal with those assets in the normal way. So often we will have, I've had last year I had a beneficiary I had to trace in Las Vegas. I had another one in another part of America, one in Australia. I've got some in France. So you will get beneficiaries abroad. So I'd say the key thing is making sure if it's done a will 9 to 10 years ago, that all the contact information of those beneficiaries is up to date and with us, so we can put that with the will. Then the executors, if they're in the UK, can deal with the getting the grant, selling any property, closing the accounts, and then essentially it will be a case of verifying the beneficiaries abroad and then transmitting the funds to them. If the person's got assets in a foreign country, then what I would say is normally it's better to do a will in that country, limited to that country, and just be careful not to revoke the English will to the extent it applies to the English assets.
So would they be better in that circumstance, Helen, to appoint possibly an English-speaking lawyer in the country that they're working in to act as an intermediary for them?
I think it depends. I think if all their assets or all their main assets that need an executor are in England, you could just have the English executors, that's fine. But it certainly wouldn't help. So certainly wouldn't hurt to perhaps give a name, perhaps a little side letter with someone trusted in that country that could be contacted if there did arise any questions of valuing assets in that country. If there was sort of some assets abroad, it would be nice to have a contact. I don't think you'd necessarily have to appoint them as executors. That maybe would even confuse things because they'd have to then sign everything from abroad. But I think a little recommendation of who to contact if there's cross-border issues would be great. Perhaps a little side letter there, yeah.
Okay, thank you. And we'll take one more question. We are actually just about out of time, but it's an interesting one from Louise here, is how often would you suggest to update your will? I know that's a question we get asked a lot.
Yeah, I mean, I normally just say to people, maybe just look at it every 5 years and just see whether it's still fine. It might be still fine for 20, 30, 40, and you never need to change it, but just look at it perhaps every 5 years, or if there's like a significant event, so a happy one like marriage or birth, but also a sad one like death or divorce or something like that. So anything kind of big major change, even moving house, probably review your will at that time.
Okay, thanks very much, Helen. Okay, well, that brings us out of time. I just want to take the opportunity to thank Helen for a really informative and useful webinar. Thanks very much for your time, Helen. As I mentioned, we have recorded this, so we'll make this available on the website a little bit later on today. And of course, if you do have any further questions that you'd like to ask Helen, I'm sure she'll be more than happy to take them by email from you. So any that we haven't covered or any that you've thought of while we've been going through, please use Helen's email. I'll just hop to the last slide so that you've got her details. And it just remains for me to say thank you very much for joining us. I hope you enjoyed it, and we'll see you on our next one, hopefully. Bye for now.